The next matter to come before the court this morning is in re LB and LB. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, please let me know when you get started. I'm keeping the clock. Also, we have the clock on the wall over there so that you can understand how much time you have left. Please don't use the names of any minors or victims. We are recording this oral argument. It will be posted online. So we make that advisement each time. Also, I wanted to thank the parties for agreeing to appear a little bit earlier today to accommodate the court's schedule. We have read the briefs and we are ready to see when you are.
Thank you, Ellen. Good morning, and may it please the court. I'm Jacqueline Corga on behalf of Summit County Children's Services, which today is the appellant, and I would like to reserve 3 minutes of my time for rebuttal. And there's a single issue before this court, and I can sum it up this way, and that is, as a general rule, the law does not require litigants to engage in absurdities or attempt the impossible. And this case involves the reality of, that is, when you need to know somebody's last known address, you can't supply one if you've never had a last known address. And so you have to know where that person has lived to have a last known address for that person. And when you don't know even that person's name, that task becomes even more impossible. And so interpreting a rule of court to require the statement of a last known address where none can exist, and dismissing the case on that basis, where the rule accommodates the absence of a last known address, we submit is error. And in this case, as you know, we have two children. One, I'm just going to refer to them as older and younger. These are two girls, both under the age of 5. The older one, her mother named an individual, had no last known address for him, did not know where he lived, and also there was a potential John Doe. For the younger child, who was also, and the younger child was born during the pendency of the older child's dependency case. For that child, there was a named individual who was actually served by FedEx and has appeared in the younger child's case, and there was also a John Doe. Again, someone who we don't even know his name. We cannot ascertain even a last known address. The court permitted service, or the Summit County Children's Services attempted service by publication, basically by posting and/or mail, according to the local rule of the Summit County Juvenile Court 6.03. And under the interpretations it had at the time, under 6.03, that local rule talks about service by publication accomplished by a newspaper if the address of the party is unknown, or by posting and or mail, or posting and mail, I should say. But the local rule allows mailing to the last known address of the party if that address is known, and that's explicitly stated in the rule under 6.03 D5. So under those rules, that's the service that Summit County Children's Services effected on the 3 gentlemen regarding these 2 children whose last known addresses were completely unknown. Now, the service rules are designed to be reasonable means to effect service, to serve notice and effect the due process upon a person. And if followed, the established case law is that if you actually effect service and the person is served, personal jurisdiction of the court attaches to that person. And that local rules are as enforceable and effective as general rules that are established by the Ohio Supreme Court. And for authority, there's the Honeywell case that we cited in the brief, and the Hubiak case, which permits proper service if the local rules are followed. And in addition, this court has already declared that local courts must comply with their local rules regarding service, and that's in the Waller case that was cited in the brief. Now, the trial court held in its opinions, both when it dismissed these cases just shortly before the permanent custody trial was going to occur, and this was after these children were adjudicated to be dependent, and after they had been, after disposition, where they'd been placed in the agency's temporary custody, where the agency then had essentially, for lack of a better term, I would call it in loco parentis authority and duty to maintain their safety and welfare. After all that occurred, the trial court, upon motion by the mother, dismissed both cases, saying that the local rules do not trump the general rules, and that it determined that its local rule fatally conflicted with Juvenile Rule 16A. The agency submits that it does not. It does not expand service, as mother has claimed. All it did was to reiterate, and the language could even be viewed as surplusage, that in addition to posting a notice, the clerk shall mail the summons to the last known of the address of the party to be served if that address is known. That is substantially the same language, with the exception of the if known following the comma, that Juvenile Rule 16A prescribes for service by publication, posting, and mail. So it does not fatally conflict with it. A conflict between rules, by the way, has to be a direct diametric opposition or contradiction with the rules that the Supreme Court of Ohio has set down, with Supreme Court of Ohio precedent, with some statute, or the local rule has to in some way usurp the jurisdiction of a higher court. For instance, by effecting discipline on an attorney, which is, as you know, in the sole authority of the Ohio Supreme Court.
Counsel, I have a question for you. You knew I did, didn't you?
I could see it.
In terms of this conflict in rules or purported conflict, did the trial court, maybe I'm misreading this, but did the trial court even get into any of that in its analysis?
It did either in, and I'm trying to recall both rulings. She had issued a ruling dismissing the case, and then Children's Services filed a motion for reconsideration. And it was either in the initial dismissal or in the ruling denying reconsideration that the juvenile court stated that there was a conflict in the rules. Again, the Summit County Children's Services submits there's no conflict because it does not diametrically oppose the general rule. And and in addition, I would also add that one of the grounds upon which the court granted the dismissal was on its assumption that mother had standing to raise a lack of service on any of the fathers. And this court subsequently, about a month or two after that decision came out, issued its decision in XH, which took the opposite position and found that where a parent is not prejudiced by a failure of service on another parent, another absent parent, that parent does not have standing to raise any kind of failure of service on the absent parent. And in this case, there would be no potential for prejudice to mother in this case because, you know, there's one father who actually has been participating in the case concerning younger child. The two John Does have never been obviously identified. They remain John Does. They're completely absent. And the other gentleman for whom mother had a name as a potential father of older child, no, she didn't have an address. There's been no participation by him, obviously. And any kind of speculation that were he properly served, that he would be participating, and that the odds that you know, with all of the host of problems that mother has that caused her children to be removed from her care in the first place, that he would essentially alleviate those problems, or that he would be a good placement for these children, that's purely speculation. And this court in XH said speculation is not enough to raise the specter of prejudice. So, again, the trial court in this case made an improper holding, in some county children's services view, and in addition, also de facto amended its own rules to require service by publication in a newspaper anytime there is no last known address, even though obviously if you have never known an address on someone, you never have a known address to have a last one, a previous one, or a first one. So that's where the impossibility comes in. But in its rulings, it de facto amended its own rules without following the procedure that the Ohio Supreme Court demands in Superintendent's Rule 5, and so that also was improper. And as Children's Services had noted to the court when it asked for authority upon which it could continue with this case, because this is a dismissal without prejudice, there were 300 other cases at least at that time that were affected by this ruling, where there were John Doe fathers for whom there was no known address at all. So, that had a great impact, and that affected a de facto amendment of the rules that's not permitted. And I would bring up also to this court that the trial court cited to this court's decision in re CH. In re CH was the trial court took that beyond its facts and extended it beyond its facts. The agency submits that in re CH is limited to its unique facts, and it was indeed unique. CH,
There was a last known address in CH.
there were actually two potential last known addresses in CH, and it was actually the mother involved who was raising her own lack of service. And she did so in the context of the question of whether the agency had used reasonable efforts to try to reunite her family. It was not, it was an oblique challenge, I should say, to the court's jurisdiction and to her due process.
You're just now coming up on that 3 minutes. You can continue or reserve as you wish.
I will reserve the time. Thank you.
Thank you.
Thank you, Your Honors. May it please the court. My name is Attorney Wesley Buchanan. I have the privilege of representing Mary Bland, the mother in this case, the FLE in this matter. As she is the FLE, she does not have any rebuttal time. As a threshold issue, this court has to first ascertain whether or not a dismissal without prejudice is a final appealable order. So before we even get to the meat and bones, this court on February 18th had asked both parties to brief the issue. So Mary would submit that this is not a final appealable order for which CSB can take an appeal. In fact, in the transcripts at 18, the trial court, in quotes, which is in Mary's brief, even indicated that the trial court couldn't say their name 3 times walking around the courtroom, end quote, to make it good service. So the first threshold is that is this a final appealable order? Civil Rule 41B4 applies to dismissals without prejudice, as noted in the brief. Then the Supreme Court and State Ex Rel. App.No v. Mason, which Mary has cited in her brief, demonstrates that a dismissal other than the merits is a dismissal without prejudice, and that's exactly what happened here. And then this court, specifically in the 9th District, went on again in Bank of America v. Edwards, and Smears v. Smears, S-M-I-R-S, which again Mary has quoted in her brief, has stated that a dismissal without prejudice is not final or appealable. And that's exactly what happened here. The trial court issued an order that dismissed the case without prejudice, even though the trial court put in the language what might be final appealable order with no just cause for delay, because that was actually in the order, and that was part of the order that was appealed from. And in addition, from Mary's perspective, the younger child was taken from her at the hospital. So she's, as far as the facts of this case, I think she spent less than a day seeing that child. As far as the single issue that CSB raises, I think this is more of a complex than that, because first this court has to find that there's a final appealable order. Second, the party seeking to initiate the case, i.e. in this case CSB, has to perfect service. They have to follow rules. Posting is not the only method for which CSB can perfect service. Personal service, gold standard. They could hire a process server, much like the Summit County Domestic Relations Court has standing orders for process or servers who are not involved with the case. The CSB could have done that with the juvenile court and say, hey, we're going to hire X, Y, and Z as process servers, hand them personal service, our gold standard. Did not.
Buchanan,
Go ahead.
how does one personally serve John Doe?
Then the rules go on, Your Honor. Great question.
I was hoping you were going to
Correct. So certified service, right, is our next level. And then the civil rules say posting by publication. They specifically provide for, if you don't know the address for a party or anything else like that, you can serve by posting. Okay? And you have to follow the procedures within that rule, which you have to post it. There has to be an affidavit. In this case, it would have to be published in the Akron Legal News for a period of time, and all of that stuff would then be filed with the Summit County Juvenile Court. All of those rules are before mailing and posting. All of those rules happen before that. That's the last situation here. So in essence, we're arguing over or and between the local rule and the civil rule, because the civil rule, as this court had said in Ray CH, it's posting and mailing. And the conflict with the Summit County Juvenile Court is, if not known, that creates an or, which is an enlargement of the rules, which the trial court cannot do. And that would make that rule unenforceable. This court in Ray ZH, which Mary decided 2013, Ohio 3904, analyzed a very similar case to this in regards to the local rule and how it affects with the civil rules. This court did not ascertain whether or not there was a difference, but it did go through the analysis and say that, again, the local rule cannot enlarge service, and that's part of Mary's issue there. So as far as the first thing, final appealable order, that's what this court has to give up, first and foremost. Second of all, and Mary would agree, that the standard of review for here would be de novo. And if this court were to get over the threshold issue, Mary would agree with CSB that this is a de novo review, because this court has to ascertain if service had been perfected or the rules have been followed. So Mary would agree that that is a de novo standard. So that's certainly there. In addition, Mary would also indicate that the juvenile court's jurisdiction does not attach until the parents have been served. That's Juvenile Rule 2Y, which again Mary has cited in her brief. This is parents. So as far as the last known address issue is concerned, the choice on, in essence, what we would call the plaintiff in this matter, CSB, the party bringing the case, they had, again, choice to make service, and they could have various different methods. So if the address was not known or was never known, the civil rules provide specific and explicit instructions on how a party can do that, and as any other party would do in any other civil action, which this is. So as far as CSB is concerned, an argument that was made was that because CSB has complied with the local rules, service has been perfected and that has been attached. And Mary would disagree with that. There was also some comments in regards to Mary's standing. In this case, that was not addressed at the trial court in the argument when Mary brought her motion to dismiss. The trial court engaged in what we would expect trial courts to do. It engaged in a legal analysis of the rules involved, i.e. the rules of service, the case law that is binding upon the juvenile court, i.e. this court's rules, and specifically in Ray CH is what the court cited, and then said, listen, and this is in the transcript, the trial court specifically addressed, and asked the prosecutor, what happens if we go through with all this, and then a dad who's not been served shows up 18 years later and can undo the entire thing? Because this court has held over and over again, and so has the Ohio Supreme Court, ad nauseum, that if you do not perfect service, everything is void ab initio. And dealing with children who, CSB and Mary would agree, that need some consistency and permanency in that regard, all of a sudden you're creating, in essence, an 18-year window. Because at 17 years and 364 days, dad can show up and say, and undo the whole entire process. And that's what the court doesn't want to do. And that's what the court stated in its analysis, at least with the oral conversation within the transcripts that are filed with the court. In addition, Mary would also indicate that her constitutional rights are at issue here. She has a constitutional right to parent. CSB may have a statutory right or duty, but she still has a constitutional right. And that's what is at issue here. Because as this court is well aware, a permanent custody trial is the death penalty for parental rights. And that is not something that's taken lightly. It's not something that's off the cuff, and it's done seriously, and that's part of the due process concerns. Because before we do this, we want to make sure that every safeguard has happened. And one might say, and specifically Mary, that the rules have been followed, because that's the portion here. So Mary would indicate that the local rules saying that you can post, or if you don't know the address under local rule 603 and 602, which would have been cited, that enlarges the rules. And according to Superintendent's Rule 1 and Superintendent's Rule 5, the trial court cannot enlarge those rules for service, because service is a substantive rule. Whether or not you have notice of a pending case that involves a constitutional right, i.e. to you parenting, is substantial. And so Mary would submit, in addition to those arguments offered, that the trial court did not make any error if this court were to, again, get over the threshold issue that there is a final appealable order that it is being appealed from. In addition, Mary would also note and add to this court that any opinion that this court may fall into the advisory category, because again, there is no live case here. The case has been dismissed. And this Mary has tried to supplement the record, indicating that the case still proceeds in juvenile court. So at this time, this case, for lack of a better term, is dead. There is no, it's not alive, because the trial court dismissed it. The parties are still engaging in litigation in juvenile court. And then as far as the advisory opinion from this court that might be issued, I think Mary would submit that the opinion from this decision would be advisory in that regard. And if the panel does not have any questions for me, we would rest on those arguments and the briefs submitted.
Seeing none, thank you, counsel.
Thank you, Your Honor.
Thank you, Your Honor. Your Honors, this is not your garden variety civil case. It is definitely not like a personal injury matter where once a 41A voluntary dismissal or any other dismissal without prejudice occurs, you go back and it's as though nothing ever happened. Okay, things did happen in this case. The Summit County Children's Services statutory, yes, rights to act as parents to these children had been established. And once this case was dismissed, even though it was without prejudice, those rights to protect these children vanished. And that is why Summit County Children's Services had to go and file new cases based on new facts, raising the specter of a new dependency of these children in order to continue to be able to protect them. At the time that this dismissal without prejudice occurred, the mother was not able to have custody of anything because she herself was, as I understand it, in a mental health facility being evaluated for competency in a criminal matter. She could not receive the return of these children, much less protect them. So, again, this is not a garden variety civil case. And the civil rule does not establish when a final appealable order is in effect. Instead, it's Revised Code 250502B, which defines final appealable orders over which this court can have jurisdiction. And under that provision, this is a final appealable order. This is a special proceeding, and it affects the substantial rights as established in the case law and the briefing we've already done. It affects It extinguished the substantial rights of Summit County Children's Services to act as the parents of these children and to protect them and keep them safe. Now regarding ZH, this court's decision in ZH did not invalidate local rule 6.02, or 6.03, I'm sorry. Instead, it clarified the requirement to name the child and or the mother in the posting to put any putative fathers on notice of the potential that they were fathers. Okay, that did not invalidate 6.03. And the agency would submit that mother still does not have standing to raise any of the John Doe's due process concerns. And that was addressed by the trial court.
And counsel, unfortunately, I need to advise you that you have utilized your time today for oral argument.
Then I thank you and ask you to reverse.
Thank you. Thank you both very much for your oral argument today. The court will take a matter under advisement and issue a decision in due course. The clerk will mail a copy of the decision to you on the day it's released, as well as the fact that it will be posted on the Ohio Supreme Court website. We are adjourned